As a property owner or manager, understanding fair housing laws makes good business sense. Violating the law, even if it's unintentional, can result in large monetary penalties and sanctions. Fair housing rights for people with disabilities is one of the most confusing areas of the law for property owners and managers. This short video will help you understand the fair housing laws related to disabilities and provide resources for further information. First, it's important to understand what a disability is. A disability is defined as a physical or mental impairment that limits one or more major life activities. The definition also includes a person who has a history or record of such an impairment, or a person who is perceived by others as having such an impairment. Major life activities include seeing, hearing, walking, breathing, speaking, or performing manual tasks. Individuals with physical or mental disabilities have the right to request reasonable accommodations, which can require changes in your rules or procedures that make sure they can fully use and enjoy their units. While there are many situations in which people with disabilities may require changes to landlords' rules, let's look at a common one: service and emotional support animals. Even if a tenant signed a lease that said pets were not allowed, and a tenant doesn't look like he or she has a disability, the landlord is legally obligated to grant the request for a reasonable accommodation when it is medically necessary. If the landlord doesn't grant the request, he or she could be sued under fair housing laws for housing discrimination. A landlord may request verification of the disability and the need for the accommodation. However, the landlord may not ask questions about the nature of the disability. It's important to understand that the landlord must grant the request unless it creates an undue financial or administrative burden. A common question is, what if the animal damages my apartment? Who pays for that? You can't charge an additional security deposit for a service or emotional support animal, but the tenant can be held responsible for any damages beyond normal wear and tear that the animal may cause. If other tenants see the animal and ask if they can have a pet too, you could tell them that as required by fair housing laws, an exception was made to the no pets rule. Keep in mind that you're not allowed to discuss the disability with other tenants. Waiving a no pet policy for a service or emotional support animal is just one example of allowing a reasonable accommodation that allows tenants with disabilities full use and enjoyment of their dwelling units. Some other examples of reasonable accommodations are providing a smoke-free environment in selected units, helping someone complete a rental application, or changing a tenant's parking space so it's closer to his or her apartment. When you receive a request for a reasonable accommodation, you should consider the following.
Ask the tenant to make the request in writing if possible. If the disability is not obvious, you may request the tenant provide verification from a medical or other professional regarding the disability and the need for the accommodation. Avoid making inquiries about the nature of an individual's disability or medical condition. If you believe that granting the request would impose an undue administrative or financial burden on your business, discuss alternative solutions with your tenant. Remember, the law requires you to interact with your tenant in good faith. Some accommodations may require the property owner to bear minor costs, for which the tenant cannot be charged. You cannot deny the request based on these minor costs. Provide a prompt response to a request for reasonable accommodation. Remember, a delay can be interpreted as a failure to provide such a request. Avoid charging additional fees or placing limitations on the individual's request. When appropriate, you may require tenants to abide by local regulations and other property rules. For example, a tenant can be required to have a service animal on a leash, to pick up after the animal, and to be responsible for any property damages caused by the animal. Fair housing laws also allow reasonable modifications for individuals with disabilities. These are alterations to the physical environment of the housing, such as installing a ramp or grab bars. In most cases, the tenant is responsible for paying for the modification and restoring the unit back to its original design. Consult with a fair housing agency or your local trade association, or seek legal counsel if you are unsure how to proceed or respond to a request for reasonable accommodation or modification.
Housing discrimination based on disability is one of the most commonly reported complaints to fair housing agencies. By not complying with fair housing laws, you expose yourself to costly lawsuits. Cases can be settled for as much as $250,000 or even more. Don't let this happen to you or your property. Educate yourself about fair housing laws and protect yourself by taking a fair housing seminar through a local fair housing agency. If you have questions or need additional information, contact your local fair housing agency, California Department of Fair Employment and Housing, the U.S. Department of Housing and Urban Development, or a local trade association.